Good evening, all. Kerala High Court Advocates Association today is the inauguration of Continuing Legal Education Program 2025 and the launch of new IT initiatives by our Honorable Mr. Justice Jamdar Sir, Chief Justice of Kerala. So without much delay, we are about to start our sessions. So first of all, I invite our Secretary of Kerala High Court Advocates Association, M.R. Nandakumar Sir, for the welcome address.
Respected President Sri KHCAA, Honorable Chief Justice Nitin Jamdar, and our committee member Sri Kumar. Today we gathered here to have a class Continuing Legal Education 2025. And our IT initiative is going to be inaugurated. Honorable Chief Justice Nitin Jamdar is an innovator in IT, information technology, in judiciary also. Words are the tools of a lawyer, and he introduced IT, information technology, also into our tool, and he will address our first session also. Justice Nitin Jamdar has rendered more than 10,000 judgments, and his vast experience, we can utilize his vast experience today. I welcome Honorable Justice Nitin Jamdar to this function for and on behalf of Kerala High Court Association and all members who gathered here. And now I welcome our dynamic President, Advocate KHCAA, who is the villain of this function, and I invite him to this august gathering. Kumar is our techie in our committee. I invite him to this function. He is rendered vote of thanks. I welcome all senior lawyers and other young lawyers and all members to this function. Thank you. Thank you.
Thank you so much, sir. Now, for the presidential address, I would like to invite the President of Kerala High Court Advocates Association, Advocate KHCAA, sir.
Warm good evening to the Chief Justice, Justice Nitin Jamdar, other dignitaries on the dais and off the dais, and my dear friends. We have taken a long time to start this program, and we have had several discussions with Chief Justice to find out the appropriate time, and he has taken a lot of efforts to be here today, keeping away many of his work to ensure that there will be some exchanges of what do the judges expect from the advocates. Let me put it this way, I've had my practice in different high courts, but the manner in which we practice here is quite different, and that difference you will see when you go to the courts where there are judges from outside the state. The way they work and the way the judges who have come up from here itself work. So mostly when the judges are from outside state, they first go to your relief, and then they have to connect that relief to your pleadings. Here it's like I've made a representation. All it is you need an order to consider the representation. So there are some basic things, and our discussions, Chief Justice was very clear that he wants to bring out these small things. We don't need a big lecture on say maritime law or aviation laws or something like that, but something which we do every day in our lives, every day in the courtrooms, and that is what Justice Jamdar would introduce us to this. The second thing I would like to say is, it's always like, what is the association doing, what is the association's next program? But the kind of crowd, I was actually contemplating in my mind whether we should move this thing to the auditorium or to the hall. But look at the kind of people who have not even got into the hall, that efforts, people who have put in the efforts to get you this event. There are a lot of efforts that have gone into. So as a matter of respect, at least that has to be respected. That is not forthcoming. But finally, one thing about Chief Justice is this: he is a man who leads by example. You will not see him talk too much. He is a man who leads by example. He shows by example what it is, and that is what is the most attractive feature about him. He has told it in very simple terms, because I was feeling embarrassed for the low crowd, but he told me it's good to have crowd that is interested in hearing and understanding than to have a big crowd with people just coming in here. So I take this opportunity to thank Justice Nitin Jamdar to have taken this much time to set this thing up, and we are keenly looking forward to his lecture. Thank you so much.
Thank you so much, sir. So, we are much privileged and honored to welcome our Chief Justice of Kerala to inaugurate this function by lighting the lamp and also deliver the lecture on our today's topic, Toolkit for the Young Advocates. Please.
Good evening, everyone. The President of the Association, Office Bearers and friends. I see both junior and senior advocates. Senior advocates are welcome, but the speech is for the junior advocates. So please don't, if I say something very basic, please understand it is for the junior advocates. I just want to show one slide, which is a very interesting concept. This graph is actually called Dunning-Kruger effect. This axis, the vertical axis, is axis of confidence. The lower axis is an axis of competence. What happens is, in any field, it's nothing to do with law, nothing to do with lawyers, it equally applies to lawyers, judges, everybody. When you start, what goes up is confidence. The competence is very low at that point. So very rapidly you reach, which is in fact very uncharitably called Mount Stupid. From Mount Stupid, something happens, some experience happens, you plunge into valley of despair there. Then there is a slope of enlightenment, and that the top is called plateau of sustainability. What typically happens is that initially, when anyone starts in any subject, even for a musician, artist, or any, there is a very rapid rise in confidence level, but not matched by competence. And then there is a fall, then slowly you gain competence and it plateaus out. The point I want to tell to any junior advocate is this, that when you reach the top at the initial stage, do not thump your chest. Neither when you fall down in the valley of despair, because it will ultimately, your competence will grow and then you'll reach a plateau. So this is what happens initially. Initially there is a lot of confidence, then it gets shattered, then people feel very despaired, as if something is wrong with them. It is a natural progression. This is what happens. So the level, though the confidence level for the junior is very high at the first peak, confidence level for the senior is the same, but they all go through this valley. You will all go through this valley and you will climb up and you will reach ultimately the level of competence. So today's structure, I just wanted to highlight before you. The president said that the crowd was low. I would have given a speech even if there was one junior advocate, because I want to speak on something which, if any of you had come to my chamber to ask me for advices, how do I go about it, I would have given in the same lecture which I am giving you today. Only thing is that I am giving it to many. So I don't propose to have any structured thought. I just want to talk to you. So I will talk to you on very distinct 4 or 5 subjects. The first one is that why do people come to advocates? Because you are a translator. You translate his thoughts, his language into legal language. And that is why he comes to you. If you keep putting up only the facts given to you by your client, then you are not doing the work of translator. Why do they come to the doctor? Because they know medicine. They will give you proper medicine. The same thing applies to the lawyer. They come to you because you know the law. You would translate his grievances in his language into language of the court. Sometimes that is glossed over. Whatever the client says is put there. That is not supposed to be done. Initially in the welcome speech, it was mentioned that the tools of the lawyers are words. It is correct. You are all wordsmiths. So, more words that you have, more appropriate words you have, more concepts that you have, your toolkit will improve. Words and clarity of thought. These are the 2 important things that you must develop as tools. I'll give you some examples as to how one can go about it. I have not studied what others did, but I'll share with you what I did. Maybe you can find it helpful. As I said, that since you are a translator, you will have to translate the language of the client into legal language. First and foremost, an advocate, the junior advocates must know, is that the facts told to you by the client fall under ambit of which provision of law, which law applies to it. That you will not know unless you have some basic idea what statutory provisions are. One day, in summer vacation, I just spent time in my seniors' chamber who had AIR manuals, series of AIR manuals. This is nothing but a reproduction of the Central Acts. So I just read the preamble of each of these acts. Just read the preamble, just read the scheme of the act, nothing more. It is not expected that you will remember any of these provisions, or it's like an examination. But when the client comes to you, you will at least know that yes, there is some act that I happen to have read. Perhaps that may apply to him. Then you go and find out the act. That is how you will have to first develop some sort of an idea where the case would fall. For that, just generally look at the provisions of law. Secondly, whenever I had time when the cases were being called out, I would go to the library and pick up a judgment at random, not to understand the ratio. That reading is different. Many persons will tell you that you must go find out ratio, you must find out what is the facts. I am not telling you to do that at all. The approach that I am telling you is different for the junior lawyers. This is read the judgment at random as a story. Just read it from start to end. What you look for there is, in those facts, what was argued. What happened to that argument, what was the law is different. But your role is not to lay down the law, that is for the judge to decide. Your role is what to argue in those facts of the case. Once you get an idea that in this fact this argument was made, you will have some structure of the argument that can be made. This is a different kind of reading that I just happen to have, then make some notes, and that way you just develop interest in reading legal provision. The moment you stress yourself as to I am reading a judgment, so to understand what was the ratio, I must remember the citation, then you perhaps lose interest in it. Just read, just find out what was argued, and that perhaps it will come to you. Also, what will come to you is a legal language. What language was used? The moment you start reading the judgment, you will get some legal phrases in your mind. When you start arguing, those legal phrases can be used. Now, ultimately, since we are addressing the advocates in the High Court, what is the core area of practice in the High Court? We have appeals, of course, and then we have writ petitions. As the complexity in the society has increased, the government is also coming out with different enactments. The people, the citizen, have daily brush with the executives. So the writ petitions have become now a mainstay of the High Courts. So writ petition concept, what is a writ petition concept? You keep hearing about alternate remedies, you keep hearing about delay, you keep hearing about the jurisdiction part of it. Just to simplify, I mean, this may not be an appropriate analogy because it's come from England and we don't have kings anymore, but just to give an idea broadly since it is called a prerogative writ. When the king in England was dispensing justice and he used to issue writs, people could directly go to the king, even though there were courts, the common law courts, the municipal courts, they were there. But people could directly go to the king and petition the king. What would they say? That I don't want to go to this statutory authority because it's acting outside jurisdiction, the authority is biased, etc. The king would somebody would come to the king's court, he would ask, why are you directly coming to me? Why are you not going to that court? And if you're coming after 2 years, why should king interfere? These are the questions that would be asked. I'm not saying that the writ petition, judges who are taking writ petition are kings, but this is just an analogy. Just to understand why judges say no to exercise of writ jurisdiction. This is because of this form of the jurisdiction that the court exercises. Now the President mentioned that I would give what the expectations of the judges are. Now let's start with writ jurisdiction. What is the first question? The writ against whom we are asking writ, is it an authority under Article 12? That's the first question that we'll ask. So every junior must first find out whosoever they are asking relief for, is it an authority on which writ will lie? Second question is, who is the petitioner? What would be his legal right? Now, of course, in a PIL, that locus has been reduced. But there also, since there are many PIs, and there's not only in this court, many courts is developed into a wide spectrum of jurisdiction. Though the locus has been diluted, the reason was that those who could not come to the court could come. But as we daily see, that sometimes that jurisdiction is misused. But that does not mean that the purpose for which the jurisdiction was developed needs to be done away with. Only that the court has to be careful, as lowered locus is not used as a tool of harassment. Now, coming back to the administrative law, which is the mainstay of most of the junior advocates now today, because what is generally challenged is the orders passed by the administrative authority. There I would recommend 2 books for all the junior lawyers. One is D. Smith's book on judicial review of administrative action, which is his PhD thesis written in 70s. Thereafter it became an absolute classic on the subject, which is used in, also referred to in various decisions of the Supreme Court. In fact, if you read the book, you will find out that what you daily argue, what you daily experience is actually there in that book, and it will resonate to you directly. Those who are practicing in writ side of the High Court, this is actually the Bible. The second is Wade's Administrative Law. That is also, these are the 2 classic books that have to be actually bought and thoroughly read. I remember buying this book when I was a junior advocate. It was 15,000 rupees that time as an import, and many others told me that why are you buying such an expensive book? And the usual thing is that what does it matter? You argue, some will get relief, what some others won't get relief. This is what happens in the courts. But then I said to my friends as to, when you start a practice as a dentist, do you not invest in a proper chair? Do you not invest in proper tools? So when you're a lawyer, you must invest in the book. So that is why I bought it. I still have that copy. There is no revision of that book as yet. It's not found necessary because it is one of the best in the subject. Therefore, once you now have a writ ready, you know that the party has a locus, he has some right. The authority is an authority under Article 12. Next step is, you must find out under which head of the administrative law or judicial review the case falls. You must have some tag, because otherwise it becomes a very general argument. There are some well-known grounds. Take it as first ground is illegality. There is a statutory provision. The authority has breached the statutory provision. The clear case of illegality. All that you have to show that this is the provision. This is the provision which structures the exercise of the power. These are the bar on the exercise of the power. The authority has breached that bar. Legality is not so difficult argument to make. Second is irrationality. This is slightly difficult, where you have to demonstrate that though the order is legal, while passing the order, the authority has behaved in such a manner that no reasonable authority can ever exercise that power. This would be also include disproportionate actions, absurd outcomes. So this is another head of irrationality, now commonly called in many judgments as witness-free unreasonableness. So this is a second ground. I am just giving you the topics. I am not giving you the details because I expect you to go further, get these books and read them. Third is the procedural impropriety. Principles of natural justice, hearing. Hearing also has many facets. There can be a departmental hearing, the individual hearing. There could be cases where which is a common misconception is some of the provision says that this order shall not be passed without any reasons. That does not mean that reasons have to be given, but reasons must exist. So these are some of the facets of the principles of natural justice. As you know, no one can be judged in his own cause. These are all basic, well-known, but this falls under the procedural irregularity. We do have concept of proportionality. Those who practice in service law also must have heard this term, that if there is a misconduct then the punishment should be proportionate to that misconduct. Similarly, any measure taken by the state government should be proportionate to the issue that they need to address. So the proportionality, this is another head under which you can challenge an administrative order. There is something, a finer concept of legitimate expectation is very difficult to prove because there could be public interest involved. There cannot be legitimate expectation against public interest. Legitimate expectation only means this, that if I am allowed to carry on a conduct for a long time, I was given an impression this is all fine, I built my whole life around this concept, and suddenly you say that no, this will no longer be permitted. That is a breach of legitimate expectation, but that's very difficult to establish. Then there is another decision of mala fides. The authority has acted mala fide. It wanted to achieve A end, in fact, which was its hidden aim, but it showed that it achieving B end. That is a colorable exercise of power, mala fides. But there the pleadings become very important. You must have specific pleadings as to why this action is mala fide. So there is discretion. Discretion is given to the administrative authorities. There can be abuse of discretion. There is also a concept of fettering your own discretion. For example, you have been given a power to pass an order in the facts and circumstances of case, each case. Suppose that means that you have to analyze each fact and decide whether this course of action is proper in this facts or this course of action. But if you develop some sort of rules by yourself for convenience or otherwise and paint all the cases in one brush, then you are fettering your own discretion, because the legislature has, or the even this subordinate instrument has given you discretion to be used in each case. You have not done it. So these are facets surrounding discretion. So generally this is the structure in which you need to approach writ courts. This is how first find out, as I said, take a general overview of the legal provisions, find out which provision the act your client's case falls. Then when you, by reading judgments, you know that this judgment argument can be made. Then you find out from judicial review of administrative law as which category it falls. Once it falls, then you have a very precise argument, and then you can ask for reliefs. Now there is another area of the nature of writs that most of you are familiar, that what is mandamus, what is certiorari. But generally this first aspect is what a practical aspect that all junior advocates need to know. The second area which is peculiar to High Court is, here you can challenge the validity of statutory rules, even up to the constitutional amendments. You can challenge the statutory provisions. In that also, there is one area of interpretation of statute, which practice generally is not that much in appellate jurisdiction, but in writ jurisdiction. There are various rules of interpretation. I am sure you are aware of them. G.P. Singh's book is, if you have not got G.P. Singh on interpretation of statute, is the absolute classic. If you have not got it, do get it. But I will just tell you broadly where the divergence is. There are only two basic principles of interpretation of statute. One is literal interpretation, read the statute as it is, or construe the statute, interpret it in a manner which may not be written there, but what you think legislature intended. There is a divergence of opinion. There are two different schools of thought, but all interpretation of statute generally revolve around this distinction. The purposive interpretation, they say, in beneficial statute, workers, the classes with the persons with disabilities, the classes which need protection. Statute granting that protection generally are more liberally interpreted than one which is penal provisions, taxing statutes. So that ultimately, all that, as I said, falls between these two classes. This is an area with every lawyer in the High Court, a junior lawyer, must master. Interpretation of statute should be your bread and butter. I have found not only here, but various courts, amongst the junior lawyers, a sort of blurring of distinction between jurisdiction. What happens is, if the junior advocate does not know the distinction between jurisdiction, distinction between writs, revision, appeals, contempt, and every argument is addressed as if it's an argument of first appeal. The problem is not knowing the distinction. Sometimes get an order against the junior even though he believes that what facts he argued merits that outcome in his favor, forgetting that not all matters can be argued like first appeal. That there may be facts, but the jurisdiction which he has invoked may not permit him to go to the facts. This distinction has to be kept in mind. Therefore, you have to keep in mind the distinction between first appeal and second appeal revision, writs and contempt. Now, quite often I have seen the confusion between writ and contempt. The writ petition, obviously, as I have said, this grants you substantive relief. Contempt is when the order of the court is breached. I am talking about civil contempt. There, primarily the court is concerned, is the order breached? And if so, does the respondent need to be punished? That is the crime. Court is thinking only on those lines. There, various concepts arise as that, is there a deliberate defiance? Is the true interpretation of the order possible? Are there some facts which permits dropping of those proceedings? There the court is not thinking about granting any relief. For that, review jurisdiction is to be exercised, or the matter needs to be challenged by the respondent. Therefore, once that distinction is kept in mind, then you realize that what you need to perhaps file is another writ petition, or may not be a contempt petition. But what I am highlighting this aspects not to give you a lecture on distinction between contempt or writ, but just to say that be aware that there are distinction between jurisdiction, and perhaps that distinction between jurisdiction is lost. And even if you feel that on facts your client had good case, perhaps it is because of the limitations of that jurisdiction you may not get an order. This is something which has to be kept in mind. So as the President said, that what do the judges look for? Some judges look for relief and then ask you the question. Let's see this one. Let's see that today there is one matter. What do I look? What do I read? As the President said, I will go to the prayer clause. What does he want? First of all, who is this petitioner? What does he want? What is his legal right? Which is the statutory provision that gives him this right? Then, once that is done, then the lawyer should tell, this is the statutory provision. Alright, which is the order? Then you go to the order. Then you have the order is passed under some provision of statute. So then that provision of the statute circumscribes the jurisdiction. Then you must be able to tell, yes, this is the order, this statute has been breached. Or you must say, what are the parameters of the statute? Then, is this statute been interpreted? If this provision has been already interpreted by any court, then you show the judgment. Yes, this is how it is interpreted in this manner. Or, if there is interpreted against you, then you bring the judgment. Tell it to the court. This is it is interpreted, but it was in the facts of those cases. My facts are slightly different. Or there is some difference in nuances. Don't let the respondent show that judgment to the court. You show it. You show it and say that this is the judgment and this is how I am distinguishing it. That is something which can be kept in mind. Secondly, again this is for junior advocates. If you are not prepared, just say that you are not prepared. Do not push through with the matter. Say that I am not prepared, ask for time. No court will refuse you time on that ground. If you are candid enough saying that I need time to research this subject, nobody will do it. So how do you address as you have 1 minute to address the court, because most of the courts are hard pressed for time. In that 1 minute, you must give some structure, saying that your client was this, let's say worker, he went to the industrial court, an order was passed in his favor, he went higher, the order was reversed, thereafter now I am here. Whole story is told in 1 minute. But if you start in the middle of the story, a lot of time is lost. First minute you must be able to make that impact and give a complete overview. This is what is necessary. This is now what should be done in the court. Now I'll speak about some other issues that which are really a silent crisis amongst junior advocates today. Not advocates, it's those who are, let's say, born after 1980, 1985, 1990. What has changed is an advent of internet. I'm a complete fan of technology, but it has negative sides. I will not talk about the content part of it. I am talking about what it does to your brain. Now with social media, you are almost constantly on consuming digital information. There is a huge information overload. Every day you are subjected to it. The content part is something else that I don't need to speak upon. But there is proven research that if you get a message or read a message, it remains in your mind for 16 minutes. Now you can imagine the irrelevant information that keeps on playing in your mind. Just to give an example, the techie part of the Bar Association is here. He will tell me what happens if a computer is on. What happens if several programs are on? It slows down the computer. There are various processes are on. Your CPU, your RAM is not available for processing. What do? You shut down each of these programs. You have to actively shut down unnecessary programs that are going in your head. Because the older generation of lawyers, now we always compare ourselves to the giants of the past and the erudition they did not have these distractions. They had only books, they had very little entertainment, and they were focused on it, and the assimilation was excellent. You give them one page, you will read the one page without interruption, keep it on side, never look at it again. Does anybody have that ability anymore? Every time you read a page, within 4 minutes your mind is somewhere else. This is a silent crisis. Unless you develop some sort of a focused attention, it's very, very difficult to get any understanding. Lot of information comes which is available on internet now, but that's pure data. As it is said, that 1 ounce of data, the 1 ounce of knowledge is equivalent to 10 ounces of data. 1 ounce of understanding is 10 ounces of knowledge, and 1 ounce of wisdom is equivalent to 10 ounces of the understanding. Now this is, therefore, do not confuse the knowledge that you get from Google search with understanding. That is different, completely different. You need to make a conscious effort of reducing the information overload. Therefore, how do you approach this? There is one way is of reading as much as you can, maybe from the digital devices. But I'm not saying digital devices per se are bad, because you have to always have the PDF file to read. I'm talking about internet overload. That is different. Books you have to read. You have to understand what is behind the books. You must understand what is the society, because ultimately law is all about society. You must understand the way the people function, behave, how the culture develops. Ultimately, do you know what is the definition, what is the core of Evidence Act? Because the Evidence Act is core of our appellate practice, trial practice. The core of Evidence Act is the definition of proved. What is proved and what is not proved? what does the definition of prove ultimately say? What a prudent man thinks is possible. Who is this prudent man? Now, the prudent man is somebody who is aware of the society. Unless you cannot be a prudent man if you just read law books. He is not the prudent man. Prudent man is one who is well-rounded. So this is something which has to be kept in mind. Our country is vast. There are cultural differences, regional differences. Travel as much as possible. I am not talking about traveling as tours. Travel to understand. The law is about human emotions. There are family court disputes. Not all of us can go through the all range of emotions. It's not possible. The only other substitute is reading the literature where the emotions are played out in detail. There are classic books which they can tell you different nuances of human emotions. Ultimately what happens is that whole thing is like a systems where system theory applies. What does the system theory says? That improvement of one part of the system does not necessarily improve the entire system, or all parts differently taken do not, even if they improve, necessarily improve the system. To give an example, there was an experiment in US where they said that let's get the best carburetor from a company of a car, best seats, best steering wheel, best tires. They got one from Mercedes, one from Bentley, and they assembled it in a garage. What they assembled it was not even a car. So the point is that all these aspects which I told you about traveling, developing the vision about the society, taking care of your mental and physical health is all part of the system. You need to develop all this together. Then only there will be a progress in law. It cannot possibly just be that you only read law books, only do this. That will not be. Your whole personality together must develop. This is what is necessary. I just don't want to give you a long lecture on this, but I just leave you the thought that which all lawyers will face as what is that you want from law? What is your definition of success in law? You will be always told success would be more matters, perhaps more fees, more money. This may be one of the parts of the success in this profession. But that's not the only success. It is still possible, though it's difficult, to create a life of your own values and live by those values. I'm sure that the journey will be difficult, but it will be worth it. I want you to cultivate a life of values. Money will come in this profession. No good lawyers would sit idle, but create a life of value. Be a torchbearer for the society and do not get stuck in the artificial notions of success. Thank you very much.
Thank you so much, Your Lordship. We are now we are moving on to the launch of our new IT initiatives.
There's just a software that we have developed for the judges, because when I came here, I found that there was software available for the judges to read e-file cases, even for the advocates. I found it very cumbersome. So my philosophy in technology that it must be made very simple, otherwise people will not use it. So my journey was to simplify as much as possible. So what I did was, I asked, of course, the IT team of the High Court. I just gave them ideas, they worked on it. I said, when I log in, I need to see the cause list, because that's how I'm used to looking at the cause list. Because I saw the interface given to the advocates or even to the judges was unduly cumbersome. Now here, if I just go to the cause list, now this is the cause list. I think they have put one dummy matter. Where is that dummy matter? 4960. 4960. Now this is the view what I would get. Now once we release it once we had this, we thought we could release it to the advocates. Maybe there's under some little work needed. This would, if you touch here, you can go directly to the matter. Here you can write on the matter. You can make your bookmarks. Let's say the next page, if I go next page, I make a bookmark. You place the bookmark. This bookmark can be edited. And you can write the same way you need a post-it. So how do lawyers will actually prepare their case? They will use a pencil or a pen to mark and put a flag. Only two things are needed. You don't require anything. This is what my endeavor was, to provide you with a pencil and a flag. Now, when this cause list will be released to the advocates, you will see the entire cause list. This is only one matter which has been now shown to you, but you will be able to click and go back to this. You will be able to click only where you are appearing. The other cause list is not obviously accessible. Here also, this is a note where either you can write or you can type. So your notes can be here. So this is your notepad. You can perhaps write on the cause list if you want to make your notes, and that's about it. This can be rolled on the cloud. So even if you're traveling, if you're given an access, you'll go straight to the cause list. You'll see the daily cause list. You click on the number in which you are appearing. This interface will show. You mark your on the pen, on the page, the same matter or your flags, and that's about it. Not only this, there is also an option of order files, which this one order was perhaps fast, so I'll show it to you. This appears here. So that main file is the matter, order file is here, and this is how we have made it simplified. So once it was done, I started taking up the court in January. Took me 2-3 months to find out how it can be improved. The technical team worked on it. Now almost it was fully ready, functional by March. But I said, let's test it out for 2 more months and then roll it out to the advocate, because unless the advocates also have this will not be a complete paperless exercise. So having done that, it's open for you. You can, if the cause list is, let's say, listed on Monday, If you're traveling, you're anywhere in any part of the world, because it's on cloud, you enter, you read your matters, mark your notes, maybe your iPad or laptop, you are ready. So, thanks to the IT team, this is being launched today. And I would urge all of you to take advantage of it.
Thank you so much, Your Lordship. Now, as a token of gratitude, we are much honored to give a memento to our Chief Justice. For that, I would like to welcome President of our association, Yashwant Shenoy sir. So, we are going to wind up our program. So before that, I welcome our Executive Committee member of the association, Dhruv Kumar sir, for the vote of thanks.
First of all, thank you so much for the not an insightful lecture. It's not a lecture actually, it's a session, an interactive session I would rather call it. And I would say His Lordship has taken us away from all that extra jargon which we have developed around us and taken us back to the basics, the very basics which we require in our day-to-day lives. May it be relating to law, may it be relating to our daily lifestyle in managing the content as well. His Lordship has taken us through the very basics in his very crisp and clean style of the very basics of a matter, starting from locus to where not, and also taken us through the very important question of the use of IT in the right way and not to lose our focus, which I think we are all victims of. We do not have the focus which our earlier generations had. Our focus is, if not to minutes, but limited to seconds due to the 30 seconds video which we often see. Lordship has taken us through that insightful thing, and I think we all will take back the very basic, the points which His Lordship emphasized, and bring that change in our lives from this moment onwards. As I would, something came into my mind. There's a widely quoted proverb or a quote from Einstein which says, once you stop learning, you start dying, and which strictly applies to our profession. And maybe that is why we as lawyers have always kept continuing legal education close to our hearts. And this day marks the beginning of the sessions of this year, and I am confident that we would have a wonderful year ahead. We would have wonderful sessions by legal luminaries. Let me take this opportunity to thank Honorable Chief Justice, Mr. Justice Nitin Jamdar, for the wonderful insights that he has given, not just to the young advocates, but I think we all would benefit from the same. And we are confident that the toolkit given by His Lordship would help us wade through the ups and downs and help us reach the plateau of success. Thank you so much, Your Lordship. Let me thank our dynamic president, as the secretary rightly mentioned, Advocate Yashwant Shenoy, for his leadership. Let me thank our secretary, Mr. M.R. Nandakumar, and needless to say, all the participants herein, the young advocates, the senior advocates, all the support staff who made this function. Thank you so much. Thank you.